Right now, in filing cabinets at trust companies across the country, the same letter goes out every few weeks. One page, a name, a dollar amount, a deadline 30 days out. Nobody reads it twice. Almost nobody acts on it. And because of that letter, billions of dollars move from one generation to the next without a cent of gift tax changing hands. The IRS has known about this letter for 58 years. It has tried to shut it down twice. It failed both times. This is not a secret in the sense of being hidden. The letter is filed in court records anyone can pull. The case that created it has been taught in law school estate planning courses since the 1970s. So if the question is, why don't lawyers want you to know about this? The honest answer is, they don't care either way. Estate attorneys recommend this constantly to clients who already have six-figure retainers and a reason to call one. The letter never reaches everyone else, not because it's hidden, but because almost nobody without a trust in place has a reason to go looking for it. Start with the man who wrote the first version of it. D. Clifford Crummy ran a fruit and vegetable canning business in California. Not Rockefeller money, not Mellon money. A regional food processor, the kind of man who shows up in business directories from the 1950s and nowhere else. In 1962, he and his wife set up an irrevocable trust for their 4 children, John, Janet, David, and Mark, ranging in age from 11 to 22 at the time. They put cash into it, $50 to start, then several thousand more across 1962 and 1963. Here's the part that mattered. Federal tax law had allowed, since 1932, an annual gift tax exclusion. A set amount each person could give to another person every year with no tax owed and no paperwork beyond a basic return. In 1962, that number was $3,000 per recipient. The Crummies claimed the exclusion on their contributions to the trust. The IRS said no. Their argument was specific. A gift only qualifies for the annual exclusion if the recipient gets what the code calls a present interest, something they can use or access now. A gift locked inside a trust, where a trustee decides when the kids actually see the money, is of future interest. Future interests don't qualify. Under that reading, the Crummies owed gift tax on contributions they'd assumed were exempt. The Crummies' lawyer had built something into the trust that the IRS hadn't fully reckoned with. Each child, for 30 days after any contribution, had the legal right to walk in and demand their share of that specific gift. In cash, no questions asked. Nobody expected the kids to actually do this. The money was meant to stay in trust and grow. But the right to demand it existed on paper, in writing, with a deadline. The case went to tax court, then to the Ninth Circuit Court of Appeals. In 1968, the court ruled in the Crummies' favor. Not entirely, the youngest 2 children's gifts were sent back for further review, but on the core question, the court was clear. It does not matter whether the right to withdraw money gets used. What matters is whether the right exists, fully and without obstruction, even for 30 days. A real right, unexercised, is still a present interest. That ruling is Crummy versus Commissioner, 397 F. 2nd, 82, and the name stuck to everything that came after it. Here's what everything that came after it looks like in practice, because this is where the letter comes in. You set up an irrevocable trust. Inside it, you name beneficiaries, children, grandchildren, whoever you want the money to eventually reach. The trust document gives each of them a Crummy power. The right, for a defined window after any contribution, usually 30 to 60 days, to withdraw their portion of that specific gift. Every time you fund the trust, the trustee has to send a written notice to each beneficiary. This is a letter. It states the amount just contributed, the beneficiary's share of it, and the date the withdrawal right expires. No notice, no exclusion. The IRS made that explicit in audits going back decades. Without proof the notice was sent and received, the present interest argument collapses and the gift tax exemption goes with it. The beneficiary almost never withdraws. That's the quiet mechanism doing the work. They get the letter, they have 30 days, the window closes, the money stays exactly where it was, compounding inside the trust. But because the right was real while it lasted, the IRS treats the gift as if it had been handed over outright. No gift tax. No use of the donor's lifetime exemption. The money is simply out of the donor's estate, growing for someone else, permanently. Run the numbers on a family that uses this properly. In 2026, the annual exclusion sits at $19,000 per recipient. A couple can each give that amount, so $38,000 per beneficiary per year, with no tax and no return required beyond basic reporting. A family with 3 children and 5 grandchildren, all named as crummy beneficiaries in one trust, can move $304,000 into that trust every single year. Compounded over 20 years at a reasonable return, that is not a gift. That is the foundation of a second balance sheet, sitting outside anyone's taxable estate, built one 30-day letter at a time. The IRS spent the next several years trying to walk the door shut. In 1954, before crummy was even decided, the agency had already ruled that gifts to minors in trust were future interests regardless of any withdrawal language unless a legal guardian existed to act on the child's behalf. It took until 1973 for the IRS to formally reverse that position and align with the court. 5 years of audits, in other words, where the letter worked in court, but the agency kept fighting it at the examination level. Then came the next fight, and it's the one that explains why the strategy got so much more powerful than the crummies themselves ever used it for. In 1991, in a state of Christophany versus Commissioner, the tax court allowed crummy withdrawal rights for contingent beneficiaries. Grandchildren who weren't guaranteed anything from the trust, who might never see a dollar of it, but who held the legal right to demand their share during the window all the same. The IRS argued this was a transparent multiplication scheme, named 16 relatives with crummy powers, claimed 16 exclusions, fund a trust meant for 2 people. The court allowed it anyway. 6 years later, in a state of Colsat, a different judge extended it further, upholding annual exclusions for 16 separate contingent beneficiaries on a single trust holding one commercial building. By the 2000s, the Treasury Department had had enough. The 2014 federal budget proposal, what tax practitioners call the Green Book, included a section literally titled Simplify Gift Tax Exclusion for Annual Gifts. Its actual goal was to kill crummy powers outright. The proposal would have scrapped the present interest requirement entirely and replaced it with a flat $50,000 cap per donor per year. Full stop. No trust structuring required or permitted. It never passed. It was reintroduced in similar form more than once. It still hasn't passed. So the letter survives, not because nobody noticed it, but because every attempt to close it has run into the same wall. Courts keep ruling that a legal right, real while it exists, satisfies the present interest test, and Congress has never mustered the votes to override that with legislation. There's a second use of the same mechanism that moves even more money, and it runs through life insurance rather than cash. An irrevocable life insurance trust, an ILIT, holds a policy on the grantor's life. Premiums have to get paid every year, and that money has to come from somewhere outside the grantor's taxable estate, or the entire point of the structure collapses. Crummy letters solve this directly. The grantor gifts the premium amount into the trust, beneficiaries get their 30-day notice, the window lapses, the trustee pays the premium. Decades later, the death benefit, often 7 figures, passes to the beneficiaries entirely outside probate and entirely outside the estate tax calculation. The entire structure depends on the same one-page document repeating itself year after year, without fail. There's a wrinkle inside the mechanism that most explanations skip, and it matters if you're the beneficiary rather than the donor. When a crummy power lapses on use, the law technically treats that as a beneficiary making a gift back to the trust, since they held a right to take cash and chose not to. Left alone, that could trigger its own tax consequences for the beneficiary year after year, compounding into a separate problem nobody intended to create. The fix is built into the tax code itself. A beneficiary can let a withdrawal right lapse every year up to the greater of $5,000 or 5% of the trust value, with no gift deemed to have occurred at all. Estate planners call it the 5 and 5 power. It sits quietly next to the crummy ruling, doing the work of keeping the whole structure from generating tax on its own internal mechanics. Trustees who don't track this exception properly can leave beneficiaries owing tax on money they never touched, which is its own kind of irony given what the letter was built to avoid in the first place. Without fail is the operative phrase, and it's where this falls apart for families who try to run it without real administration. Miss a notice. Send it late. Fail to keep a copy proving it was received. Any one of those caught in an audit can unwind the exclusion for that year and pull the contribution back into the gift tax calculation, sometimes with interest attached. The crummy letter is simple. The discipline of sending it correctly every time, for 20 or 30 years straight, is not. That discipline, not secrecy, is the actual reason this stays a tool for people with an estate attorney and a trustee rather than a tool everyone uses. Setting up the trust costs money. Administering it correctly costs more every year for as long as the trust exists. A family writing a single check to a child doesn't need any of this. A family trying to move wealth across 3 generations while staying under estate tax thresholds does, and for that family, the math is not close. A few $100s a year in trustee fees against tens of thousands in tax that never gets owed. D. Clifford Crummy never set out to build an estate planning industry. He wanted to give his kids money without a tax bill attached, lost the first round, won the second, and the court's reasoning outlived every person involved in the case. The letter that goes out today carries his name, whether the trustee sending it knows the history or not. If you're working with an estate attorney already, ask directly whether the trust documents include crummy withdrawal provisions and whether the notices are being sent and logged correctly every year. If the answer is no, the gift tax exclusion you think you're using may not hold up the first time anyone checks.